How to modify an order of protection in Illinois. An order of protection can dramatically change someone's life overnight. In Illinois, these orders can be granted after just one person's testimony, often without any input from the accused. The stakes are high: being removed from your home or losing access to your children. But there's good news. While undoing an order of protection entirely may be difficult, modifying it is always a possibility. Illinois law allows modifications to orders of protection to reflect new circumstances, permit access to a shared home, restore visitation rights, or even dissolve the order completely. Understanding the legal options and acting swiftly can help change the course of a case that once seemed final. Illinois courts have the authority to modify or dissolve previously entered orders of protection under the same principles used in civil proceedings. These orders fall into three categories: emergency, interim, and plenary. Each type comes with different standards for modification. Emergency and interim orders are temporary and often granted without prior notice to the respondent. Because of this, they are relatively easier to challenge and modify. A respondent can request a rehearing if they weren't properly notified or if they have a valid defense. These hearings must be scheduled quickly, especially when access to a shared home is at stake. Illinois law mandates that such hearings happen within 14 days to avoid delays that can infringe on due process. Plenary orders are more difficult to modify. They're issued after a full hearing or agreement by both parties. To change a plenary order, there must be new facts or changes in the law since the original order was issued. However, issues like custody and visitation can be adjusted at any time if it serves the best interests of the child. Both the petitioner and the respondent have the right to seek modifications. A petitioner can request additional protections if abuse continues or if certain remedies were left out of the original order. The law is flexible and allows modifications even if the original terms were denied for procedural reasons. In divorce or parentage cases, the dynamics shift. Orders of protection are usually consolidated into the existing family court case. Judges in these cases must consider broader family law issues like support, property division, and parenting time. Because of this, the court often modifies the order of protection to avoid conflict with its broader responsibilities. If you're asking how to modify an order of protection in Illinois, the answer depends on the type of order you're dealing with and the circumstances surrounding it. Emergency and interim orders can be modified quickly if there was a lack of proper notice or a valid defense exists. Plenary orders require new developments to justify changes. And in family court, these orders are often reshaped as part of the broader divorce or custody process. To start, the respondent must file a verified petition that outlines why the order should be modified. If the issue involves being excluded from a shared home, a hearing must be set within 14 days. The legal process is guided by specific rules about notification, proof, and court timelines. Knowing how the system works can make all the difference. A knowledgeable attorney can help navigate the process, file the right paperwork, and argue your case effectively. Even in the most complex cases, having the right law firm on your side can create opportunities for a better outcome. If you're considering modifying an order of protection in Illinois, speak to a lawyer who understands the nuances of family law and court procedure. A skilled attorney can help you protect your rights and present your case clearly. For help modifying an order of protection, contact the law office of Russell D. Knight at 1165 North Clark Street, No. 700, Chicago, Illinois, 60610, United States. Call 773-334-6311 to schedule a consultation today.